My name is Martin Blinder. I'm a forensic psychiatrist. I've been asked to say a bit about my background. Graduated from Cornell University and the Chicago Medical School. Interned at San Francisco General Hospital. Then took a psychiatric residency at UCSF, including 2 fellowships in Europe. One at St. Thomas's Hospital in London, a second at the University of Copenhagen in Denmark. I then returned to San Francisco for a 4th year of training, specifically a fellowship in legal or forensic psychiatry. I'm an assistant clinical professor of psychiatry at UC, and for 17 years was adjunct professor of law at Hastings. I've been in practice, since the late 19th century, primarily in Marin County, but also in Honolulu. I am a consultant to the U.S. Department of Justice, to the Selective Service, the U.S. Public Health Service, the FAA, and to the U.S. Postal Service, which, goodness knows, can use my help from time to time. For many years, I was chief of psychiatry at Laguna Honda Hospital in San Francisco, treatment director of the Family Therapy Institute of Marin, and was also chief of the private psychiatric inpatient service at UC and medical director of St. Luke's Hospital's partial psychiatric hospitalization program in Daly City. I've also consulted with a variety of law enforcement agencies. I'm reasonably well published. I have about 100 more or less scholarly articles for such academic journals as the Archives of General Psychiatry, the Journal of the American Medical Association, the American Journal of Psychiatry, the International Journal of Neuropsychiatry, and I've written for the legal literature as well. I've got a couple of law review articles out there, and also essays in the Journal of the ABA, the Journal of the California Bar Association, Judicature, Trial, and so on and so forth. I'm author of a half a dozen books, including a textbook, Psychiatry in the Everyday Practice of Law, now in its 4th edition, published by Thomson West. And on occasion, I have written for the popular press, and probably the only writer on this planet to be concurrently published in the Wall Street Journal and Cosmopolitan magazine, with different leads. Today, I will be talking about 9 attorneys, or perhaps 9 tactical practices, 9 habits of attorneys who drive me as a forensic psychiatrist somewhat crazy. 9 areas where I feel the collaboration between an attorney and his or her expert witness could be much improved if we could remedy these 9 areas of difficulty. I should say first that there is a basic philosophical difference between the practice of law and the practice of medicine. It seems to me attorneys begin with a theory of the case, and then they go about cherry-picking evidence and precedents to support their basic theory. The scientists and physicians are more or less scientists. Start at the opposite end, where we gather up information, which we call clinical data. Excuse me. We call that clinical data, and presumably from this accretion of data, our theory of the case will emerge. Physicians think that the attorney's approach, which is the deductive approach, is unscientific, which of course it is. We choose the inductive approach. Darwin did not have the theory of evolution in mind when he embarked upon that 2-year voyage of discovery on the Beagle. But as he gathered scientific data, he gradually discovered the origin of the species. Attorneys go the other way. They start off with this theory. It wasn't my client's shoddy construction techniques that caused your client's house to fall down, but your client's playing loud rock music every night, which shattered the foundation, and that's why the house collapsed. Or There was no intention there. My client accidentally performed fellatio on your client. So they come up with these theories, and then they hope to find supporting evidence. This, of course, drives most scientists up the wall. But any physician who regularly offers himself up as an expert to attorneys has long since accommodated to this irreconcilable difference in the often rocky marriage between psychiatry and law. So I've accepted that. I understand this is the way attorneys work. And so that is really not the purpose of my talk today. But rather I'm going to focus on certain habits, if you will, certain daily tactics that attorneys use that I think can complicate the relationship between the expert and the attorney to the detriment of the attorney's case and ultimately to the detriment of the attorney's client. You all see that I own a nice jacket. Take this off if I may. So, 9 more or less common tactics or work habits with attorneys. And the first of these would be the attorney who is, shall we say, unduly selective with regards to the information that he or she provides his or her experts. Now, I understand that case development and presentation is an inherently selective one, where the attorney pulls out, emphasizes those factors supporting the theory of the case while using various tactics to suppress those that he finds discordant. The competent attorney remains ever conscious of these inconvenient elements and presumably has a wide variety of techniques at his or her disposal with which to actively deal with them. In my experience, less skillful attorneys forget that these exist, or at least they fail to share these inconvenient facts with me, such as that their client has had 3 DUIs in the last 5 years, or that the plaintiff has been hospitalized several times for symptoms identical to those being laid at the feet of the index event, or that perhaps the client has faced numerous similar allegations in the past. So I don't find out about these things, and surely opposing counsel knows about them. Surely the opposing counsel's expert knows about them. So it is sheer folly to deny them to me. Now, again, I understand attorneys have a certain enthusiasm for their case, so they want the best possible report. The things they don't share with me may not even be discoverable, so what harm is there? But I can tell you that nothing makes me more melancholy than to receive a crucial piece of information during the course of a cross-examination. So I ask attorneys to give me everything, the complete file, including a lot of extraneous stuff. I'd rather have too much than too little. The second problem area that I find as a forensic expert is with attorneys who contact me too close to the closure of discovery. The day before discovery closes, they realize that perhaps the case hinges on a psychiatric assessment, and there I am trying to do a psychiatric assessment, read this box of records, and get a report out by the next day. It ain't going to happen. Now, again, I realize that scheduling is an occupational hazard for attorneys. Either everything has to be filed by 4 o'clock this afternoon, or the case gets kicked over until next year. Sorry, Doc, guess we won't need you tomorrow morning after all. So I realize that, as I say, that's an occupational hazard, and I share that with my attorney colleagues with a modicum of good grace. But I'm less sanguine about attorneys who had a case sitting on their desk for 2 years, and the psychiatric elements were there if they simply took the time to peruse the case. And my advice, therefore, is at least get an overview of the case early on. Contact presumptive experts early on. Get them on board. You can always drop them later on if the case takes another course, but it's very difficult to scrounge around and come up with a competent expert at the last minute. I suppose there's always the theoretical possibility that you get an adverse report because you really were premature in signing up your expert. But I think only once in my 4 decades of practice have I ever been called as an adverse witness by the other side who heard that there was another report out that they hadn't seen. The third area has to do with attorneys who, in my view, do not collaborate effectively with their experts in the preparation of a direct examination, instead relying on generic questions which they have relied upon for years and years and which, quote, worked before. I try and get at least a superficial overview of any case that is referred to me, and I know it is superficial. But what I probably know better than even the attorney bringing me in, and know in depth, are the psychiatric aspects of that case. After all, that's what I'm paid to do. I also am aware of my greatest strengths and weaknesses as an expert, and all experts have their fine points, the areas where they're effective and areas where perhaps they could be vulnerable on cross. And again, every expert is different. Nobody knows my strengths and weaknesses better than me. So I think it's tremendously important that we take the time, the attorney and I, to collaborate and develop a cross-examination that is crafted to get out what I know most efficaciously, and also lays a foundation in terms of my qualifications that plays to my strengths and finesses my weaknesses. I also know, having been around this track so many times, the likely cross-examination, because I've been cross-examined on these subjects countless times. And I like to share those with counsel in preparing the direct so that he or she asks the cross-examination questions during my direct examination. We can craft them in a much more congenial form and order than they're likely to arise on the actual cross. And it gives the cross-examiner nothing to do unless he's foolish enough to ask the same questions again, and the juries will get restless and bored. Why is he asking the doctor those questions? He's already asked them, you see. So again, I'm probably best equipped to help craft these questions, and it's a collaborative process. You as attorneys bear ultimate responsibility for the success of the trial, and I realize that. But I can make a contribution if I'm allowed to do so. As an example of what happens during a cross, because I do the full spectrum of forensic work, attorneys would like to cross-examine me in such a way as to suggest that I'm the sort of compliant forensic jack of all trades and not really an expert in this particular area. So to anticipate that on direct, I like the attorney to allow me to explain to juries all the things that forensic psychiatrists do. That we do child custody work, that we do psychic trauma work, we do criminal responsibility, we do testamentary capacity. That's what we do. And just because a general surgeon does hernia repairs and cholecystectomies doesn't mean that he can't also be an expert on appendectomies. And so it is that just because I do all these things doesn't mean I'm not an expert on this case, which is testamentary capacity, a will contest. So we can lay that foundation much better on direct examination. If it comes out on cross, I sound defensive. So let's do the cross-examination on direct and give me the tools with which to handle the cross-examination that I know is inevitable. Imagine my consternation when I get up on the stand and the attorney decides that our carefully prepared line of questioning would take up too much time or is now somewhat peripheral to his primary goals. So he runs through his usual boilerplate questions and then leaves me to face the cross-examination with neither sword nor shield. The fourth attorney who can be problematic in my professional experience is ones who fail to hear or don't seem to want to hear bad news. Now, I'm sympathetic to an attorney's single-minded enthusiasm for their case, to run the 2 or 3 or 4 year gauntlet of a case from beginning to end, you have to have a certain amount of philosophical optimism about your position. But at the same time, such focused devotion can make one deaf. And in his or her enthusiasm for their theory of the case, some attorneys fail to heed the warnings and caveats, which I'm only too happy to provide. Just 2 weeks ago, well, I guess I did the IME at about a month ago for a plaintiff attorney in an injury case, and I concluded that her client was a crock. Her client was malingering, that the symptoms with which she presented fit no clinical diagnosis with which I am familiar. And I very gently tried to tell the attorney that this is the time to cut your losses, that as far as I can tell, your client's dramatic symptoms reflect simply her aspiring to a summarily higher standard of living, but not an actual disorder. But I guess what I said didn't register. And then a couple of weeks later, this was just last week, we go through the deposition where I say it again, on the record, at the end of which the attorney takes me aside and says, "Geez, Doc, you really screwed up my case. Why didn't you tell me these things earlier?" I say, "Well, I did." So, listen to the bad news as well as to the good news. It may save you some dough. I find that same selective hearing loss sometimes when we get to trial, when an attorney taking me on direct doesn't listen to my answers. Now, I guess they think they know what the answers are going to be. But sometimes you get a surprise. And the attorney doesn't hear the surprise because they're too busy crafting their next question. You know what I mean? It's human nature. Dr. Blinder, I understand you did psychometric testing on my clients, Mr. and Mrs. Smith. Yes, sir, I did. And however, Mr. Smith was too anxious and too depressed to really complete the testing, but I was able to get good results on Mrs. Smith. Doctor, and what did Mr. Smith's test results show? It's a verbatim transcript of what happened 2 weeks ago. So put your notes down during the direct examination, and let's have a dialogue. Let's have a collaboration, a living, breathing conversation. Make our exchange more like the cross-examination. The juries fall asleep during the direct exam, but they come awake during the cross. So if you have that lively exchange on direct that ordinarily is obtained on cross, I think you can be much more effective, and your expert's going to be a lot more effective. I think one of the problems with the direct as opposed to the cross-examination is that the direct examination emphasizes the strengths of the case, which probably don't need much emphasis. It's on cross-examination that a skillful expert is able to address the weaknesses of your case and put them aside or mitigate them. So if we can do all that stuff during cross, think of how much more effective. If we do all that during the direct examination, it's much more effective. And it gives the cross-examiner with much less to do. And while we're on the subject of sensory perceptions at trial, let's move from hearing to sight. My sixth area has to do with attorneys who fail to pay attention to the visuals, to body language. They don't attend to the visual cues that would, for example, reveal the true nature of a juror's response to both the expert, the attorney, and the evidence being presented. They don't see, for example, that I'm struggling with this big pile of papers I've got there on the witness stand to find the one document that he wants to question me on. Or fails to see from my perplexed expression that I'm totally lost at this point in the direct examination. I don't know where we are, where we're going. There is perhaps no more important area for picking up visual cues and body language than in how juries respond to what is being laid before them. The jurors are silent, so the only way you're going to know what's going on inside their heads is to watch and to see. And I've learned a long time ago not to address the jury when I get on the witness stand. Now that sounds counterintuitive. It sounds contrary to what all dynamic experts do, which is that showmanship, Oprah Winfrey quality where you connect with the jurors. And in point of fact, at least initially, jurors take umbrage at that sort of uninvited intimacy. They need a little time to get to know me, to get familiar with my cadences, my accents, my manner. Jurors have an instinctive aversion to psychiatry and psychiatrists, most of them anyway. We still have horns in the eyes of some. So if all of a sudden I get on the stand and within 20 seconds I jump in their lap, I can just see those arms cross and they look away from me. So I warm them up. I give them some time to get used to me until I see that they're starting to smile a little bit and they're relaxing a little bit and they're beginning to move their bodies very much like I move my body when I testify, sending me the message that now they are receptive to me and what I have to say. But I think attorneys don't appreciate this, that they're in trial a lot, they're used to a lot of juries, and bam, like gangbusters, they're right away on the first day of voir dire, they're their best buddy. And I think juries will find that off-putting. I testified last week for an attorney who didn't appreciate why I wasn't talking to his jurors, initially at least. By the afternoon session I was, but the first 2 hours, 90 minutes, I was talking to him. Occasionally I look at the judge. So all during the direct examination, he's going like this, with his eyes, with his head, trying to, point to me. Hey, Doc, stupid, look at the jury. There are two areas of human endeavor in which foreplay is essential. This is the other one. The seventh area of difficulties is with attorneys who fail to anticipate and thus fail to remedy objections inevitably raised by opposing counsel. Direct examinations don't always go smoothly. Big revelation. Remember, you heard it here first. Things don't always go as planned, and there'll be objections, and some of these objections will be sustained. Goodness gracious, by now you should know where the areas are where an objection is going to be raised. Irrelevant, Your Honor. Obviously, the heat of the objection is directly proportionate to the relevance of the information. So I think a sharp attorney is going to have in his pocket 4 or 5 different ways of crafting those questions to get around the objection. And yet time and time again I have attorneys who simply repeat the question. They may change a word or two, but it's essentially the same question it's objected to, the objection is sustained again. So you have to have novel ways in your pocket. And I'm sitting there on the stand, even I, who's no attorney, I can think of 3 or 4 alternative ways of getting to the information that I know I have to get out if my testimony is going to be worth anything. It's going to be the supporting evidence that justifies my conclusions. We've got to get it out there. Now, I can't give them the alternative wording, but you should anticipate these things. If you can't think on your feet, and how many of us can, at least have in your pocket perhaps 3 mini questions, each of them individually too small to be objectionable, but which in the aggregate will get you where you need to go. So let's say you ask question 1, fine. You ask question 2, fine. Question 3, objection, sustained. So you can't get to 4. So you should have question 2A, question 2B, question 2C, and then you're at question 3. So try to anticipate these things. And again, your expert who knows the hazards of these areas, has had experience with sustainable objections, can help you craft alternative wording. You should have a roadmap where you're coming from, where you want to go, and that roadmap should include some peripheral side streets in case the main highway is blocked. The 8th area of difficulty that I find is with attorneys who fail to anticipate and or provide for the cost of their experts. Another big revelation, we don't always come cheap. And my contract is with you, the attorney. It's not with your client. I don't know who your client is. I haven't Dun & Bradstreet assessment of your client. I presume you're reasonably solvent. So, again, I become distressed when my bill is met with the question, gosh, Doc, didn't my client pay you? Didn't the plaintiff's insurance cover the cost of the examination? No and no to both questions. Now, I have no problem with taking payment from the client directly if we arrange for that in advance, and the client knows that's what's going to happen, and I know what's going to happen, and my bookkeeper knows that's what's going to happen. But not 4 months down the road when my first 3 bills are ignored. Also, some attorneys who work on a court-appointed basis fail to get that court order authorizing expert witnesses' funds. You can do it. Just have to remember to do it and do it in advance. So get that court order and send a copy to me. This brings me to the last and 9th problematic area, and I approach this with some delicacy. I find lately that I have been getting what I call faux referrals, pretend referrals, where the attorney calls me up, tells me a little bit about the case, seems to be signing me on, but then I never hear from the attorney again because the attorney had no intention whatever of making use of my small talents, but was simply neutralizing me so that I could not be contacted by opposing counsel. Now, this may be legal, it may even be fair, but it's not very nice. And the next time that attorney places a call to me, I may not return it. So I think it serves us all well in this relatively small community of attorneys and doctors to try and stay on good terms with all potential experts, including those who you would never use in a blue moon. You never know. So there you have it. 9 areas that furrow my brow. And I must say that I've accumulated these over many, many, many years. In point of fact, most of my experiences with attorneys has been inordinately gratifying. I'm astonished by your profession's quick mastery of wide-ranging, often alien fields. And you're starting from ground zero. This is a field that I've spent all of my life in, and all of a sudden you've got your first case dealing with these issues, and how quickly so many of you are able to grasp the essentials, then develop and discover the legal precedents and fundamentals, and then perhaps most important, have the ability to build imaginatively upon this foundation and to improvise, if necessary, on your feet, thereby achieving what, in my view, is a far better outcome than you would expect from the simple merits of the facts. I think there is no other profession with which I have worked where I can say that. So I offer these gentle criticisms in all humility. I am sure there are many attorneys who have not found working with me to be entirely a day in the country. Nevertheless, if we can, you and I, keep these challenging areas to a minimum, you will not only help to make my life a perfect existence, but will serve your clients in good stead. And I thank you all for your kind attention. Any questions for me?
I have one.
Any answers for me? Oh, we have a question.
I have one.
Yeah.
In the civil setting, the issue that attorneys present, particularly in personal injury and product liability and emotional distress cases, is the burden of a preponderance of evidence. That is, what is more likely true than not true? What is 51% more likely than unlikely? Yet in the medical field or scientific field, scientists deal with more rigid standards of evidence in order to render a diagnosis, not simply a simple preponderance. How do you square that when attorneys ask you for answers with a reasonable medical probability, or rather certainty, a reasonable medical certainty, when you can't be certain.
The question is, how do we square the preponderance of the evidence, 51 versus 49, with the higher standard of proof that the typical medical expert has been trained to require before offering an opinion with reasonable confidence? And my understanding of reasonable confidence is to a reasonable degree of medical certainty. And I think what you need to do is to have the little dialogue that you and I are having about that very issue, and explain to your expert that the standards are different. In point of fact, we have in medicine something akin to the 51-49%, where we say presumptive diagnosis, rule out, and then underneath the presumptive diagnosis, we think that the chest pain is due to an MI, a myocardial infarction. But the symptoms aren't quite right. It could very well be a pulmonary embolism. So our first guess, the first 10 minutes in the ER, these guys having a heart attack, so we put that down. But we're by no means certain, and until we do the EEGs and get the chest X-rays and so on, rule out pulmonary embolism, and it might rule out muscular strain. So we're dealing with a kind of 51-49. If I had to guess, that's probably what it is, but I am by no means certain. So, in other words, doctor, if that's what your best assumption is, that's good enough for us here in court. Now, if you can go beyond that, and why would you want to bring a doctor who's so ambivalent about the diagnosis in the first place? But if you can go beyond that and you say you're 80%, 90% certain, that's really good enough for us. And there's nothing wrong with saying, when I examined the plaintiff and went through all my tests, by the time I was done, I was quite satisfied that he had the diagnosis that I offer here today. Now, there's a possibility that I'm wrong. We're not dealing with physics here or chemistry. This is not an exact science. But he's been checked out by several other people. We've had the passage of time to confirm my initial diagnosis. And so, to the extent that a doctor can be certain about anything, I think indeed your client suffered this head injury in that fall 2 years ago, and not because his mother dropped him on his head when he was 4 months old. Another question. Yes, sir.
How do you deal with clever defense attorneys who have your transcripts from previous testimony 1, 2, 3, 4, 5, 10 years before, where, at least on the surface, it looks like you're taking an opposite position, and you have no particular recollection of that prior testimony? How do you deal with it?
Excellent. Question is, how do I deal with opposing counsel who has my track record, transcripts dating back to the late 19th century, in which it would appear, at least on the surface, that I arrived at diametrically opposed conclusions compared to the facts with similar facts. And worse, I probably don't remember that case back in 1923. First, the useful expert. And if you've practiced forensic psychiatry for as long as I have, we have to assume that I'm useful and that I still have some usefulness, and I have not been used up like courtesans are, where they're, by the end of their 15th, 16th year, because they are courtesans, they are revealed to be the kind of hired gunslingers that they are. But an expert who's honest, who arrives at his conclusions, and will tell the attorney that hired him, I really can't help you here, is not going to have too many misadventures in court. He's not going to end up in court with egg on his face and with a track record that supports his flexibility, shall we say. Still, so since I'm absolutely confident that the conclusions that I reach were arrived at honestly, and were not a product of the hopes and expectations of the attorney bringing me into the case, I don't have to worry about those kinds of time bombs ticking away somewhere in a transcript. So that theoretically, I should be able to explain away what would appear to be a disparate conclusion. And so when I'm faced with that cross, I'll say, I don't remember at this point the facts of that case. But if I could have that transcript, please, when we take a little break, let me go over the transcript, not just a little parts you're cherry picking to read to me. If I have 5 or 10 minutes, I can show you why that particular plaintiff had a very different clinical picture than the one we're talking about today, justifying these diametrically opposed conclusions. Now, I cross my fingers that the judge will give us 10 minutes, and I go over the transcript, and so far, so good.